Okay. The reason that we are doing this year is because ICJ is very different than a lot of how the other committees function, but it's also a very important part of how the United Nations works. We're also doing this because last year we felt like delegates could have used the opportunity to have a little bit more information and training before the conference began. So we're doing that here today. Hopefully everybody can see my screen and hear me okay. Um, if not, feel free to unmute, but I'm going to go ahead and get started. Okay, so the ICJ, in the real world, it's located in The Hague, Netherlands. Um, sometimes you'll hear the ICJ referred to as The Hague, actually. They're the same thing. But essentially, it's the primary legal or judicial organ of the United Nations. It's made up of 15 elected justices that serve 9-year terms. So at AZMUN, the 15 elected justices are all delegates. So you all should know who you are representing already at this point. In front of the court, there are advocates that argue the cases. Those are essentially like attorneys or lawyers, just like in a trial in the United States, for example. Um, they argue the case back and forth, and then the justices, come up with an opinion and decide the outcome. You may have most recently heard about the ICJ in the news regarding the case South Africa versus Israel, where the court ordered Israel to do everything in its power to prevent genocide from occurring there. So that's just a very recent ICJ update that kind of gives you an idea of um, what kinds of conflicts and things they work on. The ICJ really has two main roles. The first thing that it does is it releases opinions on contentious cases. So this is cases where maybe a UN member state is bringing a suit against another state. Um, in this case, each party or each state appoints advocates to argue their case in front of the ICJ, and then the ICJ justices will make a decision. Decisions in contentious cases are considered binding, which means that the Security Council actually has the power to enforce whatever decisions are made in contentious cases. At AZMUN, our cases this year are all three of them are contentious cases. Another option is advisory opinions. So sometimes UN organs, like, for example, the General Assembly or a subcommittee, could request legal advice from the International Court of Justice on a specific topic. In that case, the ICJ issues an advisory opinion, kind of giving legal advice to the UN on how that body should proceed. It's not binding, it's just a suggestion on how the ICJ thinks that body should proceed. That's really more of an internal process. It's less of like a lawsuit, like contentious cases are, and more of just the UN seeking legal advice on something. Okay, sorry, I keep moving around your guys' little squares. Hopefully you can see everything okay. Um, so in the legal system in the United States, but also during the International Court of Justice, there are kind of three things that you want to consider while we're going through these cases with the ICJ here at AZMUN. The first thing that you should really consider as part of your legal reasoning is questions of fact. And what that means is you, as the justices, need to determine, based off of the evidence and the arguments from both sides, what the events that occurred were that led to the case. So, if it's land dispute, maybe, you know, you need to figure out from the evidence what actually happened. Was there a country that sort of instigated conflict, or, did troops move into a certain area, or, did a country cut off a water supply? You have to figure out what actually happened. And this is difficult because a lot of times the two parties to the case or the two sides may not agree on the facts. So the facts is the first part. Justices need to determine what they think actually happened based on the evidence. It's really important. The second part is the justices need to reason and answer questions of the law. And what that means is, as a justice, you need to figure out, okay, what laws apply in this case? Is there some sort of treaty or agreement or maybe some resolution from a UN body that kind of dictates this issue? For example, let's say it's a human rights violation or a case relating to human rights. The International Convention on Human Rights is probably an important piece of law that you should look at and, figure out if it applies to the scenario in question. It's important that because it's the UN, it has to be international law. So, you're not basing this on the laws in the United States or the laws in, even the Netherlands where the ICJ is. You're basing this purely on international law. So it's treaties, conventions, the Universal Declaration on Human Rights is another good one. Any sort of international agreement is kind of the legal basis for these cases. And then lastly, based on whichever law you think applies, and sometimes it can be more than one, by the way, as well as the facts of what occurred, you decide who you think is in the wrong or who you think should win the case, and then what relief should be granted. The relief portion is like what needs to be done to resolve the conflict, essentially. Does anybody have any questions about this? I know this is a lot of information. This is like intro to legal education. So hopefully this is not too much information. But if it is, feel free to use the chat or just to say questions out loud.
I have a question.
Yes.
You mentioned that on the part of questions of law, we should like know about the international laws or agreements. And my question is, where can I find that like the international law?
Yeah, so it really depends on which case you're looking at. Um, there's no there's no set place to look for international laws, unfortunately. Maybe an example is you can look at treaties between the two countries from the past, or you can look at, for example, the Universal Declaration on Human Rights is like a widely accepted. It's a agreement that has been signed by many countries. Those sorts of things. So unfortunately, there's not a central place to look for where international law exists. But I'd encourage you to look up, um, what sort of treaties your country may be involved in related to the topic in the case. Does that make
Yes,
sense?
yes, thank you.
Okay, yeah, no problem.
I have another question.
Yeah, go ahead.
Generally in model UN, like we have a country and that country like has an opinion on things. So
Mhm.
as judges, are we supposed to take in the opinions of the countries that we're from or not really? It's like just supposed to be international law.
Yeah, it's really supposed to be based off what you think for the international law. The justices in the ICJ are appointed, they're elected by the General Assembly and the Security Council, but they require a majority of both bodies. So it's people who are appointed based on kind of their prestige and their ability to be unbiased. Um,
Okay.
so certainly your country will play a small role in your opinion, but it really should be based off of your judgment, based on the argument that you'll hear during the conference. Does that make sense?
Yes, thank you.
Okay, no problem. Yeah, questions of law is definitely the trickiest one. These three cases that we'll be seeing during the ICJ here, you should be able to find information online regarding what kind of international laws and treaties might apply. So feel free to look that up as well. Okay, so rules and procedures. It's there's a big part of it is very similar to normal committees, but there are also some differences. So that's just what I want to talk about here. So the first thing that the ICJ is always going to do right at the beginning of the conference is they're going to set the docket. So they'll use Rule 8.4, which is the setting the order of agenda items to establish the docket. Basically, that just means you're saying what order you're going to hear the cases. Unlike other committees, you can't move back and forth between topics. Once you submit or once you establish the order at the very beginning, you're stuck with that until the end. You can't move on until you're done with the first case. Um, So, just keep that in mind when you're using this motion at the very beginning and setting this order. That's the order you're stuck with for the rest of the conference. Each case is going to have two phases. The first phase is the oral arguments. This is what you see when you picture a courtroom, where you have the advocates standing up there, they're arguing their case, they're showing you evidence, they can answer questions that the justices have. And there's a really set schedule for how this happens, we'll look at in a second. Then, once that's done, the justices, which is all of you, the delegates, will enter deliberations. And what that means is this is kind of the debate, the typical AZMUN style debate, where you give speeches and you ask points of inquiry. You're essentially discussing amongst yourself, the other justices, what you think about the case, and eventually you'll write an opinion. It's very similar to normal debate at AZMUN, like I mentioned. There's just a couple extra rules. So first, let's look at the first phase, oral arguments. So as I mentioned, this is where each side of the case will present their arguments. The advocates will be members of the AZMUN staff, so you don't have to worry about preparing to make the oral arguments yourself. As you can see here, there's a really strict schedule. Each side will have an opportunity to present an opening argument. Then the justices will have a chance to ask questions. When you ask questions, you can just blurt them out. You don't have to wait to be recognized by the chair during oral arguments as you normally would during formal debate. Then the defendant does the same. And then there's a chance for rebuttal and then any closing question and answers. So it's really important that delegates arrive on time to their committee because, as you can see, it's a pretty strict schedule here. As I mentioned, during the question and answer phases, you don't need to wait for recommendation. You can just speak. In fact, if you've ever heard the United States Supreme Court oral arguments, it's kind of surprising because you'll hear the attorney talking and then all of a sudden a justice will just interrupt and ask them a question. And that's what you can do here as well. During this first section, the oral arguments, you want to absorb as much information as you can. Surely you've done some background research, but you really want to make sure that you're getting as much information from the advocates as you can. You should take notes during this section just because just to help you remember things during debate later. And if you really need to, you can recall the advocates later during formal debate. But after these opening arguments are done, the advocates will leave or they'll sit down and they'll stop participating unless you ask them to come back. I see in the chat you asking me to repeat something, Anna. Which part would you like me to repeat? Okay. I'm going to keep going, but there is going to be a recording of, oh, there we go. Everything of the oral arguments. Yeah, so just make sure to be on time to your committee because there's a really strict schedule here. During any question and answer portion, delegates you all can just blurt out your questions. You don't have to wait for the chair to call on you, for example. And you really want to get as much information as you can. Don't wait. Don't wait to get information later. You want to try to get as much of it as you can during the oral arguments. So take notes, ask clarification questions if you need them. This is a really crucial part of the ICJ proceedings. Then the next phase is the deliberation. So the advocates or the attorneys will leave or they'll sit down, they'll stop presenting to you. And now is where you enter formal debate, just like any other AZMUN committee. So delegates will give speeches, you can do points of inquiry, motions, you can use unmoderated caucuses, moderated caucuses, all the normal stuff. To really discuss, what your thoughts are about this case, keeping in mind those three main processes in legal reasoning that I mentioned: determining the facts, determining the law that applies, and then the opinion. There are a couple differences in the ICJ, and I just wanted to point those out. One of them is that speakers and points of inquiry are recognized by the president of the ICJ, not the chair. So the president is a delegate. I'm not sure if any of you are the president or not, but if you are, you will choose the speakers and points of inquiry. The president will also conduct the votes, so they'll call the names of all the justices during any voting procedures. And if the president is not there or they leave for some reason, then the vice president would fill that role. There is also a deadline for opinion submission for each case. So, you have a few hours to work on it, but you can't just take as long as you want. There is a specific deadline on when you have to be done with your opinion. And then there are two motions that are special for the ICJ. We have the roundtable discussion, which is similar to a moderated caucus, except instead of just calling on speakers, as they raise their placard, roundtable discussion requires that all of the justices speak. So if I make a motion for a roundtable discussion and I want each justice to speak for 1 minute, we're going to go down the line of all 15 justices, and all 15 justices have to speak about whatever the topic is and sort of give their opinion. So that's a little bit different. That's a different motion that only applies to the ICJ. The second one is Rule 13.9, invite parties to dispute. This motion is for if you're in the middle of deliberations, but you have a question for the advocates that you didn't get to ask during the opening arguments, or maybe you didn't have the question at first, but it popped up somewhere during your discussion. You can recall the advocate and they'll come stand in front of the room and answer questions that you have. This requires a super majority to pass this motion, which means a 2/3 majority vote. So that's why it's so important to ask as many questions and get as much information as you can during the opening arguments, because it's harder to bring back the advocates after you start deliberations. Does anybody have any questions about kind of those two phases that I mentioned before I move on to the next? Yes. So the vice president, you act just the same as a justice. So does the president. The only difference is the president will call on speakers and points of inquiry, and if the president is not there, then the vice president will do it. So other than that, you act just like any of the other justices. I hope that makes sense. There is still a chair from AZMUN, so they will be there to kind of walk the president and vice president through that as it's happening if needed. So don't worry too much. Okay, the next section is the verdict. So this is the decision that the court reaches after they're done with their deliberation. So in a normal MUN committee, you're working on resolutions to pass. In the ICJ, you're writing a verdict. It's pretty different. There's no, we don't do the preambulatory operative clauses like you do in a normal AZMUN committee. This is more of sort of an essay format. And it's made up of different parts that we'll talk about right now. So this is very similar to the United States Supreme Court and many other Supreme Courts around the world. The verdict can be made up of multiple opinions. The opinions are the majority opinion, which is whatever most justices think. You all should be discussing and deliberating throughout the committee, so you should know before we get to a vote what the majority opinion is. So this is whatever most justices believe. Concurring opinions are where maybe you agree with the outcome, you agree with the majority that so-and-so should win, but you have a different reason. So you can write an opinion that expresses you agree with the outcome, but explaining your different reasoning for why you believe that. And then lastly is the dissent. The dissent is when you don't agree with the majority opinion. You can still have your voice heard by drafting a dissenting opinion. All of these together are put into the verdict, but the majority opinion is the one that has the most justices signed onto it, and the one that will ultimately become the binding case law in this case. So it's the responsibility of the president and the vice president to kind of work together while writing these opinions to figure out, okay, which one is the majority opinion? Which one is going to have the most justices' support? And you can do that just through discussion or informal polling. There's no strict procedure there. Some cases, if everybody agrees, then there might be just a majority opinion. Not every case is going to have a concurring or dissenting opinion, but it can also have as many or as few concurring or dissenting opinions. So it's not a requirement to have those. It's really just, if the court doesn't all agree, then you can write those other two. I hope that makes sense. Yes, yeah, as the vice president and the president, they also work on the opinions of the court. There's nothing they can't do. They act just like a normal justice, plus a couple additional responsibilities. Okay, so any opinion that is written has to include these parts. The date, the name of the judges, the parties, which are the two sides of the case, a summary of the trial, a stipulation of the facts. So again, this is that first part that I mentioned. What does the court actually think happened? What events occurred? The legal ground, so what case or what laws or what treaties apply? And then the relief granted to the winning party. So what does the winner get, basically? There are really two choices. There's damages, which is a financial payment. So the loser would pay the winner a certain amount. And there's an injunction, which is where the court says, okay, the loser has to stop doing this. Those are kind of your two choices when it comes to deciding what relief should be granted. Once the opinions are all done and they're all put together into one verdict, there would be a closure of debate on the topic. We would vote on the verdict. The ICJ votes via roll call. And at this point, everybody should agree to the verdict because they should agree with the majority. And if they don't, they've agreed to either the concurring or the dissenting opinion. So their opinion is written somewhere in there. Even if they don't agree with the outcome, the justices are saying, okay, we went through the legal process, we're approving this verdict. And then the justices will read their opinions and they will all sign the verdict. Does anybody have any questions about that? Once again, I know this is a lot of info, and we'll be sharing this video after the fact so you can find it. Yes.
So the opinion, so each judge has their own opinion, but the verdict is just the whole body as a whole?
Yes. So, yeah, the verdict is all of the opinions basically compiled into one document. Thank you for this question. Not every justice has to write an opinion. So, if there are justices that agree with each other on the majority, they can together write that opinion. So not all, 15 of you are expected to write your own opinion. You're kind of like a resolution. You're expected to find people that you agree with and write opinions together with them. And one of them will be the majority opinion because that'll have the most justices. The difference is you can only work on one opinion as a justice. So keep that in mind. Obviously you're not going to agree with the majority and write a dissenting opinion. You have to choose one or the other. Okay. There'll be another point for questions here. We're almost done. So I'll take more questions at the end. So I want to give you a quick outline as to how we want position papers to work for the ICJ. These are just suggestions. There's not really a strict rubric. As long as it shows that you've done some research and preparation for the ICJ, we'll accept it. These three things that we have here are more suggestions. So if you've already started, don't worry. That's okay. You don't need to go back and change your position paper. But this is just to give you a jumping off part if you haven't started yet. So your position paper should give a really brief overview of the facts of the case. So what happened that led to this conflict? That should just be brief, maybe a couple sentences, just really quickly summarizing what has occurred that led to this case. The second part is kind of the more intense part, and this is researching the applicable international laws. So talk about, oh, there's this treaty and it applies to these two countries because they both signed it in 1973 and it clearly talks about water rights. That's just an example. But yeah, research what laws you think may apply. Now, for some of these are real ICJ cases, and I know for at least two of them, the ICJ has already rendered an opinion. Try to avoid that from swaying your opinion of the case. You do not want to come to the case already thinking who you think is going to win, because you're supposed to be unbiased as a justice. You're supposed to really take the information in from the advocates to kind of form your opinion. So try not to come with an opinion before the conference, because you don't want to seem biased. In our simulation, the trial hasn't happened yet. And can you imagine a trial where the judge said at the beginning who they already thought was going to win? That wouldn't seem very fair. So even though some of these cases do have outcomes that are already, decided by the ICJ, try to not let that sway your opinion. In fact, I wouldn't even look at the outcome if possible, but that might be difficult to avoid while you're doing your research. Okay, so that is all of the slides that I have. We have an email here that you can use to email any questions that you have during or leading up to the conference. It's the ICJ email. You can reach our chair directly that way. Yeah, I'm going to show you all one more thing, and then I will take any questions that anyone has. So I'm not sure if you all have seen it yet, but there is a guide to the ICJ, which has most of the information I just shared on our website. So I'm just going to show you how to get there if you haven't already seen it. Okay, hopefully you can see my screen here. So this is arizonamun.org, just our website. If you go to AZMUN 62 conference and then committees, we've got all our committees here, but we have the International Court of Justice background guide, so just a brief summary of each of the three cases, and then the rules and procedures, which is kind of an overview of what I've just showed you about how to write an opinion, the two special motions, sort of the schedule for the conference. So please use that as a resource in your preparation. Here's a quick look at the background guide. So as you can see, kind of a brief overview of each of the three cases here. Okay. Does anybody have any questions? I know I kind of just shared a lot of information, so feel free to ask anything. There's no stupid questions. Okay. Well, if there aren't any questions, that is all that I have for today. Like I said, this email is a great way to reach us if you have any questions that come up before the conference. I hope this has been helpful. As I mentioned, we will go ahead and publish this video online. That way you can review it as well as the other justices that couldn't make it. Let's see. Yep. So yes, please reach out if you have any questions ahead of time, but if not, we will plan to see you at AZMUN 62. Thanks, everyone.